Therefore, the petition of ECP is not maintainable and liable to be dismissed on this preliminary ground. I am relying on 2 recent judgments of the Supreme Court.
एक चीज बताएं, when you use the word aggrieved person, does Article 185 require that? If the judgment is wrong, I may not be aggrieved by it. Can I not still challenge it under? They've come under 185. They have not come under Article 199, which of course starts with the word any aggrieved person except habeas corpus. So let's see, 185, does the word aggrieved mention or no?
It's not mentioned, no doubt about it. But generally,
suppose someone challenges a judgment of the High Court,
yes,
and he may not be aggrieved, but he may say this judgment is wrong.
May not
so
be,
if he was a party in the lower court, will we say, oh, you're not aggrieved by it, but would it really matter? We agree with you, but it's not a requirement of the Constitution that they have to be aggrieved, or is it?
It may not be in Article 185, but may I submit that generally the principle that is applied for any kind of writ jurisdiction and separate jurisdiction is under Article 199. So, though the appeals or the petitions are filed under Article 185 Clause 3, but that does not mean that the principle applicable to Article 199, because it is initiated through Article 199.
But there they were the respondent, not the petitioner. Yes. So the requirement of aggrieved would be on the petitioner, not on the respondent.
No doubt. But sir, the result is that it is continuation of that. I was the petitioner, here they are the petitioners. But the question
ये बताइए, suppose ऐसे मफरूजे के तौर पे
जी जी
कोई और केस में हाई कोर्ट कह देता है I hereby abolish the Election Commission of Pakistan. Judgment आ गया.
Yes, another party aggrieved can come home.
ECB can't come. अजीब सी बात नहीं होगी, या वो किसी मेंबर को रिमूव कर दें कि I don't like this member's face, I remove him. I mean, I'm giving you absurd examples so the point can be appreciated. So ECP can't come, जी मेरे मेंबर को हटा दिया, unless it's a co-Toronto rate तो अलग बात है, ठीक है, या हम ये सारे मेंबर्स बदल दो, नए वाले अपॉइंट कर दो.
जावेद हाशमी केस में भी ECP था पिटिशनर इस कोर्ट में. जावेद हाशमी का जो केस है ना कल साइट हुआ है,
ये जरा मुझे ज्यादा इसमें,
but I'm relying on judgments subsequent to the Javed Hashmi's case. Let me show these judgments.
जावेद हाशमी का केस तो 5
These are
मेंबर
very recent judgments. One is 2023 judgment.
जो आपने हमें 2 दे चुके हैं वो रिपीट ना कीजिए, वो मैंने अभी भी नोट आपको बता देता हूँ
जी.
वो आप एक ऑम्बड्समैन का था और एक वो था कमीशन का, वो
जी सर,
हाँ वो वाले हमने नोट कर लिए, उसके अलावा कोई बताना चाहें?
अच्छा,
तो आपने पहले दिन बता दिया था.
एक जजमेंट, इसके अलावा दूसरी PLD 2020 सुप्रीम कोर्ट 5-1. There is also now one more judgment.
PLD 2020 सुप्रीम कोर्ट,
That PLD 2020 सुप्रीम कोर्ट 586.
ये वही वाला है, कल वाला है.
वही 2 जज.
हाँ वो तो मैंने नोट किए हुए हैं.
एक केस में जो था वो कंपटीशन कमीशन था, स्टैट्यूटरी बॉडी. दूसरे केस में ओम्बड्समैन था.
इलेक्शन पिटिशन कमीशन का कोई डायरेक्ट केस है आपके पास जिसमें इलेक्शन कमीशन का पार्टी और उसमें ये होल्ड हुआ हो कि आपकी तरफ से आगे आप तो अगली पार्टी हो ही नहीं सकती?
ड्रॉ पैरेलल, वो मैं आपको अर्ज किए जाता हूँ कि इसमें क्या वजूहात है, व्हाट इज अ पैरेलल बिटवीन द टू. एक थर्ड जजमेंट है जो अभी रिपोर्ट नहीं हुई है.
दे दीजिए, कॉपी दे दीजिए.
उसकी कॉपी से आपको दे दी.
दे दीजिए.
A recent judgment authored by your lordship, civil petition number 3532 of 2023.
जावेद हाशमी तो फुल मेंबर है.
आप दे रहे हैं कॉपी?
जी
इसकी कॉपी नए वाले जो कह रहे हैं वो सबके दे रहे थे ना ये बार.
अच्छा, ये राइट टू इंफॉर्मेशन वाली जजमेंट
इसी पॉइंट
नहीं, ये जजमेंट है जहां रजिस्ट्रार सुप्रीम कोर्ट ने कोई पिटीशन फाइल की थी और जनाब ने होल्ड किया है कि इट कैन नॉट.
राइट टू इंफॉर्मेशन वाली,
राइट ऑफ इंफॉर्मेशन,
राइट ऑफ इंफॉर्मेशन वाला
अहमद अली वाला केस.
हाँ हाँ, तो हमने दे दी अब इंफॉर्मेशन. नहीं तो इससे आपके केस से क्या ताल्लुक बनता है?
नहीं सर, इसमें सिर्फ ये है कि सुप्रीम कोर्ट एज ए कॉन्स्टिट्यूशनल बॉडी कैन नॉट बी ए पिटिशनर. दिस इज व्हाट हैज बीन, एज आई सी, हेल्ड इन दिस जजमेंट इन पैरा 9 ऑफ द जजमेंट. May I read out this para 9?
अगर आप हमें दे देते तो आसान होता.
Another 5 minutes I'll provide.
आप पढ़ने
जी सर, पढ़ देता हूँ.
पढ़ लीजिए.
The question of maintainability of the writ petition filed by the registrar of the Supreme Court before the High Court was raised before the learned single judge who held the petition to be maintainable by referring the cases of Registrar Supreme Court of Pakistan versus Hassan Akbar and Registrar Supreme Court of Pakistan versus Qazi Wali Muhammad. The Hassan Akbar case, this Hassan Akbar's case is 1987 Pakistan Criminal Law Journal, and the other Qazi Wali Muhammad wala case is 1997 SCMR 141. The Hassan Akbar case was with regard to complaint against Assistant Advocate General who had appeared before the Supreme Court when he was not enrolled out of the recommendation of the disciplinary committee. Therefore, it cannot be cited as a precedent entitled to Supreme Court to initiate litigation. In the other case, Qazi Wali Muhammad was terminated from the service of the Supreme Court and filed an appeal before the Federal Service Tribunal, whose order reinstating him was challenged by the registrar before the Supreme Court under Article 212(3) of the Constitution. This court held that Qazi Wali Muhammad was not a civil servant as defined in the Civil Servants Act 1973, therefore the tribunal did not have jurisdiction. The registrar had not initiated litigation in Qazi Wali Muhammad case. He had not filed the appeal before the tribunal. The particular facts and the very limited scope of these two cases cannot be treated as precedents for registrar to initiate litigation on behalf of the Supreme Court, particularly when the journalists neither case had discussed this aspect. So meaning thereby the institution of the Supreme Court through registrar cannot be a petitioner. This is as I read this judgment about. I'll just
there is another thing, na? The other thing is a superior court. Registrar means the superior court is before the High Court. So here it's not an hierarchy of Election Commission of Pakistan. I mean, it's a separate constitutional body. So they get a judgment. They cannot appeal it. It's very strange. Either then you say, then they can't be sued either. If they can sue, they can also defend. No, you can sue but you can't defend. ये क्या बात हुई?
No, defend before the court, but you cannot be appellant because
ये मुझे इसकी logic नहीं समझ आ रही.
Institution, sir, because it is an institution making decision, judicial or quasi-judicial. It is now for the parties in
अगर
dispute.
कोई भी उन्होंने ऑर्डर पास किया कि अपने अकाउंट्स हैं हाई कोर्ट के रिमत दो, तो वो तो फिर उसका तो लोग मजाक उड़ाने लगेंगे एक कॉन्स्टिट्यूशनल बॉडी का कि आपने हाई कोर्ट का फैसला मान लिया, आपने चैलेंज भी नहीं किया. तो मतलब ये नहीं, हम ऐसा सिचुएशन, सॉरी आई कैन नॉट एग्री विद दिस. देखें, आई विल गो द एक्स्ट्रा माइल टू रिस्पेक्ट constitutional bodies, which includes Parliament, which includes the Election Commission of Pakistan. If Parliament enacts unconstitutional laws, we will strike them down. If they do anything unconstitutional, we will set that aside. But otherwise, let everybody operate, empower them to operate within their domain. So, अब ये तो की बात नहीं कि High Court cannot make a mistake. They pass an order again, which is, and they say cut off your hand, you can't go. तो फिर हम ये भी कह सकते हैं आप पिटिशन ही नहीं फाइल कर सकते थे.
सर देखिए,
आपको किसने राइट दिया पिटिशन?
मेरी गुजारिश है कि यहाँ पर जो इस केस में भी सर्विस ट्राइब्यूनल इज ए स्टैट्यूटरी बॉडी, रादर ए कॉन्स्टिट्यूशनल बॉडी अंडर आर्टिकल 212. Their decision was being challenged before the Supreme Court by the Supreme Registrar. It was held, no, we can't do that because we are not there to.
चलिए, आपका पॉइंट मैंने सुन तो लिया, मगर I don't agree with it. Let me be so straightforward and say it.
But there can be always situations where I can say the exceptions can be made. I'm not saying
ये कॉन्स्टिट्यूशनल बॉडी है, सबऑर्डिनेट कोई बॉडी होती है, हाई कोर्ट खुद चैलेंज कर रहा है अपना जजमेंट. वो आपकी बात सही है कि भाई आपको क्या फिक्र है, आपने तो फैसला कर लिया, आप अपना जजमेंट क्यों चैलेंज कर रहे हो?
बिल्कुल
जी, ठीक है.
एग्जैक्टली. अब यहाँ पर एक और एस्पेक्ट है इसी का.
जी.
बिफोर द 18th अमेंडमेंट before the 18th Amendment,
Let me tell you something which may be good news or may be bad news for you. हमें बताया कि Election Commission has extended the time till 7 p.m. today for allotment of election symbols. तो जरा सा तेजी करते हैं.
उसमें मैं एक गुजारिश करूंगा at the end कि इसको अगर जनाब एक दिन के लिए उनको because the thing is
नहीं, आप अपने आर्गुमेंट्स खत्म करें, हम इसको फैसला करें.
मैं उसके एंड पर बात करूंगा. मैं इसलिए आखिर में सर इसमें गुजारिश ये थी कि 18th अमेंडमेंट से पहले आर्टिकल 17 में एक शिक थी आर्टिकल 17 उसमें 4 क्लॉजेस होती थी आर्टिकल 17 के.
पढ़ ली.
17th prior to 2010 before
Every political party shall, subject to law, hold intra-party elections to elect its office bearers and party leaders. ये आप पढ़ना चाह रहे हैं ना?
जी वही.
अब ये खत्म हो गई है.
Every political party shall subject to law hold intra-party election to elect its office bearers and party leaders. Now this was omitted under the 18th
But
Amendment.
it was brought back by 2007 Elections Act.
Yes. अब वो election act के तहत.
जी.
Why I'm quoting this example? As your lordship were pleased to observe yesterday that it is a constitutional body. I'm submitting that after 2010, it is only exercising functions under a statute, not under the constitution. So it is a statutory body for all intents and purposes. So therefore, while interpreting the Election Act, its role is a statutory role, not entirely a constitutional role, because constitution does not require holding of inter-party elections after 2010. Now this is all under the Election Act or previously under the Political Parties Order of 2002. So therefore my submission would be that ECP, for the purpose of the intra-party election, is now a statutory body performing statutory functions, and therefore these two judgments which pertain to statutory bodies, whether as ombudsman or whether as a competition commission, they are at par with that of Election Commission of Pakistan, exercising this function of regulating the
पेशावर हाई कोर्ट का जो जजमेंट है हामिद साहब, उसमें उन्होंने लिख दिया है कि ईसीपी के पास कोई राइट ही नहीं है इंटर पार्टी इलेक्शन के बारे में बात करने का, देखने का. वो एक उनके सेक्शंस में है. तो अगर वो इसको चैलेंज नहीं करते तो वो तो उनके खिलाफ वो जजमेंट होता तो वो तो लॉ ही इनफेक्टिव हो जाता ना बात के लिए.
देखिए वो एक और एस्पेक्ट है बिल्कुल, एंड वेरी एबली आर्ग्यूड बाय मिस्टर अली कि it has no jurisdiction, but the question is whether ECP as a constitutional body is any different to other statutory bodies in this regard, in this respect, only in this respect, where it is only exercising statutory function and statutory law. So therefore my submission is, for all intents and purposes, the election ECP performing functions under the Election Act is a statutory body, and has same law applies to it as that of Competition Commission or Ombudsman.